Foundations of Western Political Thought. Module 4, Rights, Property and Revolution. John Locke. John Locke returned to England in February 1689 aboard the same ship that carried the future Queen Mary. He had spent 5 years in Dutch exile, watched from a distance as the political situation in England transformed, and now came home to a nation that had just done something extraordinary, deposed one king and invited another to take his place, relatively peacefully, on the grounds that the first had violated the fundamental terms of government. The Glorious Revolution, they called it, and Locke would become its philosopher. The man who explained after the fact why what had happened was legitimate. His 2 treatises of government, published in 1689, would become the foundation of liberal political philosophy. Less than a century later, Thomas Jefferson would draw on Locke so heavily that passages of the Declaration of Independence read like paraphrase. But we should be careful not to read Locke backwards, through the lens of what came after. He was not writing a timeless treatise on the rights of man. He was intervening in a specific political crisis, answering specific opponents, and his arguments carry the marks of that context. What we cover today, Locke's state of nature, very different from Hobbes's war of all against all. His theory of property, grounded in labor, with provisos that may matter more than the theory itself, consent as the basis of legitimate government, and the right of revolution when that consent is betrayed. The appeal to heaven when earthly justice fails. By the end, you will recognize Lockean fingerprints on every constitution that limits power and every declaration that asserts rights against the state. The context. England in the 1680s was in crisis. Charles II had no legitimate heir. His brother James, next in line, was openly Catholic in a Protestant nation. The question of succession split the political nation into factions, those who would accept James, those who would exclude him, and those willing to use almost any means to prevent a Catholic monarchy. Locke was close to the Earl of Shaftesbury, leader of the exclusion movement, and later of more dangerous conspiracies. When Shaftesbury fled to Holland and died there in 1683, Locke's position became precarious. He followed his patron into exile, living quietly in Amsterdam and Rotterdam, working on philosophy and corresponding carefully with friends back home. The 2 treatises were largely written during this period, not as abstract philosophy, but as political argument. The first treatise is a demolition of Sir Robert Filmer's Patriarcha, which defended absolute monarchy on the grounds that kings inherit Adam's authority over all mankind. Locke found this absurd and said so at length. The second treatise, the one that matters for us, lays out his positive theory of government. When James II finally took the throne in 1685, fears of Catholic tyranny seemed confirmed. Within 3 years, he had alienated almost everyone. When William of Orange landed with a Dutch army in 1688, James' support evaporated. He fled to France. Parliament declared the throne vacant and offered it to William and Mary jointly. Locke's treatises, published the following year, provided the theoretical justification. The king had violated the trust placed in him. The people had exercised their right to resist. A new government had been established by something like consent. All of this was legitimate, and here was the argument for why. The state of nature. Like Hobbes, Locke begins with the state of nature, the condition of human beings before government exists. In chapter 2 of the second treatise, he lays out his picture. and it is very different from Hobbes's. For Hobbes, the state of nature is a war of all against all. Life is nasty, brutish, and short. There is no property, no justice, no security. Rational self-interest drives everyone to seek absolute sovereignty as the only escape. Locke's state of nature is not a war. It is a condition of freedom and equality governed by natural law. Human beings have reason, and reason reveals the law of nature that no one ought to harm another in his life, health, liberty, or possessions. We are all God's workmanship, sent into the world by his order and about his business. We belong to God, not to each other. Therefore, none of us may destroy or enslave another. This is a moral claim, not just a descriptive one. In Locke's state of nature, there are already rights and wrongs. There is already property. Your body is yours, and what you mix your labor with becomes yours. There is already a kind of justice. Everyone has the right to punish violations of natural law. The problem is not that the state of nature is lawless. The problem is that it is inconvenient. When you are the judge in your own case, you tend to judge in your own favor. When you must enforce your own rights, you may lack the power to do so. Disputes have no impartial arbiter. Punishment is haphazard and often disproportionate. So people agree to leave the state of nature and form political society, not because life without government is unbearable, but because it could be better. They give up their individual right to judge and punish in exchange for the benefits of common rules, impartial judges, and collective enforcement. The social contract. This is Locke's social contract, and it differs from Hobbes's in crucial ways. For Hobbes, the contract is a one-time surrender. You give up your natural freedom to the sovereign, completely and irrevocably. The sovereign is not a party to the contract. He stands outside it, holding the power that everyone else has surrendered. You cannot take it back, because taking it back would mean returning to the war of all against all. For Locke, the contract is more like a trust. The people place power in the hands of government for specific purposes, the protection of life, liberty, and property. The government holds this power as a trustee, not as an absolute owner. If the trustee betrays the trust, the power reverts to those who granted it. This means government is limited. It can only do what it was established to do. It cannot arbitrarily take property, because the whole point of government is to protect property. It cannot rule by arbitrary will, because the whole point is to replace arbitrary will with settled law. It cannot place itself above the law, because law is what distinguishes political society from the state of nature. And this means resistance is possible when government systematically violates its trust, when it becomes destructive of the ends for which it was established. The people may alter or abolish it. This is not rebellion. Rebellion is the government's act when it rebels against its own purpose. The people merely reassert the authority that was always there. Property. Locke's theory of property has been enormously influential and enormously contested. In The State of Nature, he argues in chapter 5 of the second treatise, the earth and its fruits are given to mankind in common. This was the standard Christian view. God gave the world to Adam and his descendants, to all of us together. But this creates a problem. If everything is common, how can anything become mine? Do I need everyone's consent before I can eat an apple? That would be absurd. I would starve, waiting for permission. Locke's solution is labor. Every man has a property in his own person. This nobody has any right to but himself. The labor of his body and the work of his hands are properly his. When he mixes his labor with something from the common stock, when he picks the apple, plows the field, encloses the land, he joins to it something that is his own, and thereby makes it his property. This happens without consent. Property arises naturally, before government exists, through the act of labor. Government does not create property, it protects property that already exists. This is a crucial move. If property precedes government, then government cannot legitimately take it away arbitrarily. Taxation without consent is theft. Redistribution by royal whim is tyranny. The implications for the England of Locke's day were clear. The Stuarts had claimed prerogative powers over property, forced loans, ship money, seizure without parliamentary consent. Locke's theory said this was not merely unwise, but illegitimate. The king could not take what was not his to take. But Locke is not a libertarian in the modern sense. He places limits on appropriation. First, the spoilage limit. You may take from the commons only what you can use before it spoils. To appropriate more than you can use is to waste what God has given for all, and this natural law forbids. You cannot let apples rot in your barn while others go hungry. Second, the sufficiency limit, the famous enough and as good proviso. Your appropriation is legitimate only if there's enough and as good left for others. You cannot claim the only waterhole in the desert and let everyone else die of thirst. Your right to acquire is bounded by others' right to do the same. These provisos matter enormously. They suggest that property rights are not absolute. They exist within a framework of natural law that imposes obligations. The earth is given to all mankind, and private appropriation is justified only when it does not harm others' ability to appropriate for themselves. Your Catholic friend who argued that Catholics were the great defenders of property was not wrong, but neither is the Protestant tradition negligent here. Locke's provisos echo something like Catholic social teaching. Property is legitimate, but it carries obligations. The rich hold their surplus in trust. Absolute property rights that leave others destitute violate the deeper purposes for which property was instituted. Later thinkers would argue about what happens when these conditions no longer hold. When the commons is exhausted, when there is not enough and as good left, when appropriation by some necessarily excludes others. Locke did not fully address this, perhaps because in his world, with a vast American continent apparently open for settlement, scarcity seemed a distant problem. We do not have that luxury. The provisos may be the most important part of Locke's theory for us, because they raise the question, in a world of finite resources and 7 billion people, what does legitimate appropriation even mean? Money and inequality. Locke does address one puzzle. If spoilage limits appropriation, how can there be large estates? How can anyone legitimately own more land than they can personally cultivate? The answer is money. By mutual consent, people have agreed to use durable goods, gold, silver, eventually paper, as stores of value. Money does not spoil. So you can sell your surplus apples for money, accumulate the money, and use it to acquire more land, the spoilage limit is effectively circumvented by consent. This explains, and to some extent, justifies economic inequality. Before money, no one could accumulate much more than anyone else. After money, vast disparities become possible. But the agreement to use money is consensual. Everyone who uses money has tacitly agreed to the system that makes inequality possible. Critics have found this argument convenient. Locke himself had investments in the slave trade and colonial ventures. His theory of property through labor was used to justify the dispossession of indigenous peoples. They did not cultivate the land in European fashion, so they had not truly appropriated it, so it was open for settlement. We should not dismiss Locke because of these applications. Ideas often travel beyond their author's intentions, but we should notice that his theory was not neutral. It served certain interests, justified certain arrangements, and could be deployed for purposes he might or might not have endorsed. Consent and legitimacy. How does government acquire legitimate authority over individuals? Only by consent. Locke answers in chapter 8 of the second treatise. Bear, no one is born subject to a government. Political obligation arises from voluntary agreement. But this creates a problem. When did you consent? You were born into an existing society, under existing laws, with no memory of any contract. How can you be bound by an agreement you never made? Locke's answer is tacit consent. By remaining in a society, using its roads, enjoying its protections, you implicitly consent to its authority. Anyone who inherits or purchases property under the laws of a country thereby consents to those laws. You are free to leave, and if you stay, you are bound. This has struck many readers as too convenient. The conditions for genuine consent, real alternatives, absence of coercion, full information, are rarely met. Most people stay where they are born because leaving is costly or impossible, not because they have reflected on the social contract and found it satisfactory. Tacit consent seems to mean simply that you have not actively rebelled. Locke might respond that he is not describing ideal conditions, but real ones. In a world where governments exist and someone must rule, tacit consent is the best we can do. The alternative, requiring explicit consent from every individual, would make government impossible. But the tension remains. Liberal theory wants to ground obligation in consent, but actual consent is rare. The legitimacy that flows from genuine agreement may be thinner than Locke hoped. The right of revolution. Here is the most radical part of Locke's theory and the part most relevant to his political context. In chapter 19 of the second treatise, titled Of the Dissolution of Government, Locke makes his case. When government betrays its trust, when it uses power arbitrarily, attacks the people's rights, makes itself tyrannical, the people may resist. They may alter or abolish the government and establish a new one. This is not rebellion, but the lawful exercise of a power that never left them. Locke is careful with his language. He does not call this rebellion. Rebellion, from the Latin rebellare, to renew war, is what the government does when it turns against the people. The tyrant is the rebel. The people who resist him are merely defending what was always theirs. This matters rhetorically. In 1689, people needed to believe that what had happened was legitimate. The old king had fled. A new king had been installed. Oaths had been broken and remade. Was this lawful, or was it usurpation? Locke provided the answer. James was the rebel. William was the restoration of proper order. The people had exercised their natural right. Who decides when the threshold is crossed? The people themselves. There is no external arbiter. Each person must judge whether the government has violated its trust and act accordingly. This worried Locke's critics, and rightly so. If everyone can decide when revolution is justified, the result might be constant instability. Every malcontent, every faction, every zealot with a grievance might claim the right to overthrow the government. Hobbes' chaos looms. Locke has several responses. First, people do not revolt over trifles. They endure long trains of abuses, give the benefit of the doubt, hope for reform. Only when the pattern becomes unmistakable, only when it is clear that power is being systematically abused, do they take the drastic step of resistance. Revolution is the last resort of the desperate, not the first resort of the ambitious. Second, the greater danger lies in denying the right of resistance. A government that cannot be resisted has no check on its power. It will tend toward tyranny because it can max. The possibility of resistance keeps government honest. It reminds rulers that their power is conditional, that they govern by permission, that the permission can be withdrawn. Third, and this is the pragmatic Locke, revolution usually fails. The costs of resistance are high. Most people have more to lose from instability than from moderate oppression. The threshold at which people actually take up arms is very high. Rulers need not fear that every unpopular policy will spark rebellion, but they should fear that systematic tyranny will. This is a gamble. Locke is betting that the costs of occasional unjustified rebellion are lower than the costs of unchecked tyranny. History offers evidence for both sides. The American Revolution, Lockean in inspiration, produced a durable republic. The French Revolution, also drawing on ideas of natural rights, produced the Terror. Perhaps the difference lay not in the theory, but in the circumstances, the culture, the character of the people. The appeal to heaven. Locke uses a striking phrase for the right of revolution, the appeal to heaven. When there is no earthly judge, when the government itself is the oppressor, and there is no higher authority to which the aggrieved can turn, there remains one tribunal, God. The oppressed appeal to heaven. They take their case to the ultimate judge and act accordingly. This is not merely rhetorical. Locke takes seriously the idea that tyranny violates divine law, that resistance to tyranny is sanctioned by God, that the outcome of the struggle will reflect God's judgment. The appeal to heaven puts revolution in a theological frame. It is not mere power politics. It is righteousness against wickedness, with the Almighty as witness. Later, readers, less confident in providential judgments, might translate this differently. The appeal to heaven becomes the appeal to history, to posterity, to the moral conscience of mankind. The revolutionary does not know if he will succeed. He knows only that he must act, that tyranny is intolerable, that silence would be complicity. He stakes his life on his judgment and awaits the verdict. This is dangerous. Every fanatic believes he is appealing to heaven. Every tyrant claims divine sanction. The question of who is truly righteous and who merely thinks he is cannot be settled in advance. It is settled only afterward by success or failure, and success proves nothing about righteousness. Locke knew this. He was not naive, but he thought the alternative, denying any right of resistance, was worse. Better a world with occasional unjustified rebellions than a world where tyrants sleep soundly, knowing they can never be challenged. Toleration. Locke's letter concerning toleration, published in the same year as the two treatises, addresses the relationship between church and state. It was written in Holland, where Locke had seen religious diversity coexisting with commercial prosperity, a practical demonstration that toleration need not mean chaos. His argument is simple and powerful. The magistrate's authority concerns external things, life, liberty, property, public order. The salvation of souls is not among them. Government has no competence in religious matters, no commission from God to enforce true doctrine, and no means of producing genuine faith. Coerced worship is worthless. You cannot torture someone into sincerely believing. This seems obvious now. It was not obvious then. For centuries, the assumption had been that religious uniformity was necessary for political stability. One king, one law, one faith. Dissent was not merely theological error, it was political subversion. If people could disagree about the most important things, the things pertaining to eternal salvation, why would they agree about anything else? Locke's answer: precisely because religious questions are so important, the state should stay out of them. The state's business is earthly. It can protect your body and your goods. It cannot save your soul, and attempts to enforce religious conformity do not produce genuine faith. They produce hypocrisy, resentment, and ultimately the very conflicts they were meant to prevent. Therefore, the state should tolerate different religions, allowing each to worship as it sees fit. Churches are voluntary associations. You join and leave as conscience dictates. The state's only proper role is to maintain civil peace, intervening only when religious practice threatens public order. This was radical for its time. Wars had been fought, people burned, nations torn apart over questions of doctrine. The Peace of Westphalia in 1648 had ended the 30 Years' War by allowing each prince to determine his territory, religion. But this was toleration as exhaustion, not toleration as principle. Locke went further. The state should not merely permit diversity as a concession to reality, but should embrace it as the proper order of things. Locke's toleration had limits. He excluded Catholics, not for their theology, but because they owed allegiance to a foreign prince, the Pope. They had divided loyalty. They could not be trusted to obey the civil sovereign when the Pope commanded otherwise. He excluded atheists, because without belief in God, oaths and promises could not be trusted. The entire system of civil obligation rested on the assumption that promises were binding, that oaths meant something, that there would be divine punishment for dishonesty. Remove God, and the whole structure of trust collapses. These exclusions reveal the political anxieties of his moment. They also show that toleration was not for Locke an absolute principle, but a pragmatic arrangement with pragmatic limits. He was not a modern liberal, arguing that all beliefs are equally valid. He was a Protestant, arguing that the state should not enforce Protestantism. Still, the letter marked a decisive step. It argued that religious diversity need not threaten political order, that conscience is beyond the state's rightful reach, that civil peace can coexist with theological disagreement. These ideas would shape the American First Amendment and the broader liberal tradition of church-state separation. The influence. Locke's influence is difficult to overstate. The American founding is unimaginable without him. Jefferson's Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, is Locke in American idiom. The substitution of pursuit of happiness for property has generated much scholarly discussion, but the structure is pure Locke. Natural rights, equality, government by consent, the right of revolution when government becomes destructive. The Constitution's architecture, separation of powers, checks and balances, enumerated and limited federal authority, reflects Lockean suspicion of concentrated power. The Bill of Rights, protections against government overreach, guarantees of property, due process, religious liberty, codifies Lockean principles. Beyond America, Locke shaped a liberal tradition broadly: constitutional government, individual rights, religious toleration, the rule of law, consent as the basis of legitimacy. These ideas spread through the 18th century, fueling revolutions and reforms across the Western world. But influence is not vindication. Ideas that spread may still be wrong, or right in some contexts and wrong in others. Locke's critics, then and now, have raised serious objections. The consent theory is problematic. Tacit consent is thin. Most people do not choose their government in any meaningful sense. They are born into it, remain because leaving is costly, and obey because disobedience is punished. If this counts as consent, consent has been defined so broadly as to justify almost anything. Property theory is problematic. Labor mixing works in a world of abundant resources. It works less well when resources are finite and prior appropriation by some excludes others. The provisos may require more redistribution than Locke's heirs have generally acknowledged. The revolution theory is problematic. Who decides when? In practice, those with weapons and organization who may or may not represent the people, who may or may not be right about tyranny, who may or may not make things better rather than worse. Still, Locke gave us a vocabulary and a framework that we have not escaped. When we argue about rights, we are arguing in Lockean terms. When we worry about executive overreach, we are thinking Lockean thoughts. When we insist that government must respect limits, we are invoking Lockean principles. Perhaps the best way to read Locke is not as having solved the problems of political philosophy, but as having posed them clearly. What are rights, and where do they come from? What makes political obligation legitimate? When may the governed withdraw consent? These questions remain open. Locke gave us one set of answers. We are still looking for better ones. Locke and Hobbes. Let us step back and compare. Say, both begin with the state of nature and the social contract. Both ground political authority in consent rather than divine right. Both are responding to the religious conflicts that had torn England apart. Both are trying to answer the question, on what basis can one person legitimately command another? But they reach opposite conclusions about sovereignty. For Hobbes, the lesson of civil war is that divided authority is fatal. There must be one final power, absolute and undivided, or there will be chaos. The sovereign cannot be limited, because any limit implies a higher authority, and then who is really sovereign? The logic drives relentlessly toward absolutism. For Locke, the lesson is different. Absolute power is the problem, not the solution. James II had absolute pretensions, and look what happened. He became a tyrant and was rightly deposed. Power must be limited, divided, conditional. The people must retain the ultimate authority to judge when government has failed. The difference begins in the state of. For Hobbes, it is intolerable. War, fear, death, any order is better than none. For Locke, it is inconvenient but not catastrophic. There is natural law. There are natural rights. Life without government is not solitary, poor, nasty, brutish, and short. It is merely less convenient than life with government. If the state of nature is a horror, you will pay any price to escape it, including absolute submission. If the state of nature is merely inconvenient, you will insist on terms. Locke's milder state of nature grounds his limited government. Who is right? Hobbes would say, Locke is naively optimistic about human nature. Strip away the institutions and see how long natural law restrains people. The veneer of civilization is thin. Underneath is the war of all against all, waiting to resurface whenever authority weakens. Locke would say Hobbes is cynically pessimistic, and conveniently so. If humans are really as bad as Hobbes claims, why would the sovereign be any better? The sovereign is human too. Absolute power in the hands of a creature as dangerous as Hobbesian man is the worst possible arrangement. Perhaps both are partly right. Humans are capable of cooperation without government. Anthropologists have documented many such societies, but humans are also capable of horrific violence. When order breaks down, history documents that too. The question is, which tendency dominates? Under what conditions and what institutional arrangements best restrain the worst while enabling the best? This is an empirical question as much as a philosophical one, and the evidence is mixed. The Commonwealth inheritance. For those of us in the Commonwealth tradition, Locke is foundational, but perhaps more complicated than he first appears. The Australian colonies were not founded on Lockean principles of consent. They were established by imperial fiat, populated initially by convicts who had certainly not agreed to transportation, governed by appointed officials responsible to London. Yet Australian political culture absorbed Lockean ideas over time. Responsible government, parliamentary sovereignty, rights against arbitrary power, the sense that government is a trust, not a possession. The Australian Constitution, for all its particularities, rests on assumptions about limited government and the rule of law that trace back through Westminster to the very glorious revolution that Locke theorized. The tension between foundation and principle runs through Commonwealth history. Canada's founding peoples did not all consent to the same arrangement. French Catholics, English Protestants, First Nations with their own prior claims. New Zealand's Treaty of Waitangi involved consent of a sort, but its terms remain disputed more than a century and a half later. South Africa's transition to democracy was a kind of new founding by consent. But what of those who did not consent, who were simply outvoted? Everywhere, the messy reality of how states actually come into being sits uneasily with the clean theory of government by consent. Perhaps this is the honest conclusion. Locke provides not a description of how legitimate government arises, but a standard against which actual governments can be measured. No existing state fully meets the standard, but the standard still matters. It tells us what to aim for, what to criticize when resistance might be justified. The colonies became nations. The nations became democracies. The democracies claim legitimacy through the consent of the governed. That the original founding did not involve genuine consent does not settle the question forever. Each generation may renew or withdraw consent. Each election is, in principle, an opportunity for the governed to endorse or reject the arrangements under which they live. Whether this is genuine consent or merely its shadow is a question Locke left us to wrestle with. How to recognize Lockean ideas today? When someone argues that there are rights the government cannot violate, no matter what, rights that precede government and limit its authority, that is Locke. When someone argues that property is not a gift from the state, but a natural right the state exists to protect, that is Locke. When someone argues that taxation without representation is illegitimate, that consent is the basis of political obligation, that is Locke. When someone argues that a government which systematically violates rights has lost its legitimacy and may be resisted, that is Locke. When someone argues for religious toleration on the grounds that faith cannot be coerced and the state has no business saving souls, that is Locke. And when someone argues that these principles sound fine in theory, but create instability in practice, that rights talk provides a vocabulary for endless grievance, that the consent of the governed is a fiction that masks the reality of power, they are arguing with Locke taking Hobbes' side in a very old debate. The Hobbesian might say, look at the world Locke made. Endless litigation over rights. Paralyzed governments unable to act decisively. The appeal to heaven invoked by every faction with a grievance. Revolution as a permanent possibility, destabilizing every regime. Was stability not preferable to this? Lockean might reply, look at the world Hobbes would have made. Absolute power unchecked by law, no recourse against tyranny, the subject reduced to the status of property, liberty, sacrificed on the altar of order. Was this not too high a price? We live in the middle of this argument. We have neither Hobbes's absolutism nor Locke's consent in pure form. We have limited government, more or less, rights with exceptions, consent that is largely tacit, revolution that is threatened but rarely exercised. The model may be the best that humans can manage, or it may be a failure of nerve. Hobbes and Locke would disagree about which. Pause and consider. Before we move on, let me leave you with a question. Locke grounds property in labor. You own what you have worked for. This has intuitive appeal. Surely the farmer who clears and cultivates a field has a stronger claim to it than someone who merely desires it. But the argument has been challenged from multiple directions. Some say you benefit from roads, laws, education, inherited knowledge. Does this mean society, meaning the state, has a claim on your earnings? But this proves too much. Everyone benefits from civilization's inheritance. That inheritance belongs to all of us, not to tax collectors. And you did not receive it for free. You participate, contribute, pay as you go. The exchange runs both ways. Others say, if property comes from mixing labor, what about those who inherit without laboring? Locke allows inheritance, but the justification is less clear. Does the heir have the same claim as the one who cleared the field? Still others, following Hobbes, say the whole notion of natural property is confused. Property is a legal convention, created and enforced by the state. Before the state, there is no stable mine and thine. Locke's natural right is a useful fiction at best. Locke did not answer every objection, but his critics faced their own problems. If property is merely conventional, why should the state respect it? If society's contribution justifies taxation, how much taxation? The questions multiply. We will not settle them here. That is enough for this lecture. Next, we turn to the epistemological questions that reshaped how people thought about everything, the limits of reason, the problem of knowledge, and what can be known about morality and politics. We begin with Hume, who would take Locke's empiricism in directions Locke might not have welcomed. End of Module 4.